Let's dive right in with Section 1. What exactly is VAWA?
VAWA stands for the Violence Against Women Act. But hey, despite the name, the absolute first thing you need to know is that VAWA applies to all genders. It is a vital legal pathway that lets survivors of abuse self-petition for a green card. And that term, self-petition, is the real game changer here. It means you file independently, entirely without the abuser's knowledge, consent, or participation. It literally rips the immigration control right out of the abuser's hands. Congress actually created these protections about 30 years ago based on a simple yet incredibly powerful idea. Public safety improves when victims are not afraid to come forward. The whole goal was to ensure that immigrant survivors could report crimes and cooperate with law enforcement without that paralyzing fear of deportation hanging over their heads. Moving on to Section 2. Who qualifies for protection? Well, you can't just apply simply because you suffered abuse. Eligibility rests on 4 very specific pillars. First, a qualifying relationship. You must be the abused spouse, child, or parent of a U.S. citizen or lawful permanent resident. Second, there has to be evidence of battery or extreme cruelty. Third, you've got to demonstrate good moral character for the past 3 years. And fourth, you have to prove shared cohabitation with the abuser. I want to pause right here on that extreme cruelty requirement for a second, because, abuse isn't always physical. USCIS defines extreme cruelty really broadly. It includes psychological and emotional abuse, isolating you from friends, controlling your finances, and, crucially for our discussion, weaponizing your immigration status. Threatening someone with deportation or hiding their immigration documents absolutely counts as extreme cruelty under VAWA. All right, let's look at Section 3, the 2025 policy changes. This brings us to a major update known as Policy Alert PA 2025-33, which dropped in December 2025. Basically, USCIS completely rewrote its guidance on VAWA self-petitions. Just look at this comparison. Before, you just had to show you lived with the abuser at some point in the past. Now, the new rule strictly requires you to prove you lived together during the qualifying relationship. So if you're a spousal petitioner, living together before you were legally married just doesn't count toward this requirement anymore. And with this policy shift comes much stricter evidence standards. USCIS rolled these changes out citing program integrity after seeing a massive 360% spike in filings. What this means on the ground is that your personal declarations carry a lot less independent weight today. Officers are prioritizing hard, documentary proof. We're talking joint leases, utility bills with both names at the exact same address, and corroborating affidavits from people who have direct knowledge of the shared living arrangement. Which naturally leads us to Section 4. The application timeline, 49.5 months. Just let that sink in for a second. As of June 2026, that is the average wait time for 80% of VAWA I-360 petitions to be processed. That is over 4 years of waiting just to get the initial petition approved. For self-petitioners and their families, that number isn't just data. It represents years of profound, stressful uncertainty. So why on earth is it taking so long? Well, all new VAWA petitions are now funneled into a specialized division called the HART unit. That's Humanitarian Adjustment, Removing Conditions, and Travel Documents, over at the Nebraska Service Center. Now, the idea was great, create a specialized environment for humanitarian review. But the reality of staffing that unit and training officers on those new 2025 standards has created a deep, incredibly frustrating processing backlog. Let's actually look at how this all builds into a complete timeline. First, you spent a couple of months gathering that strict evidence and filing Form I-360. Right now, it's taking 6 to 7 months just to get a simple receipt notice from the HART unit. Then you wait that massive 49.5 months for the I-360 approval. And if you're approved, you then apply for adjustment of status, which is getting the actual green card. All told, survivors are staring down a 4 to 6 year journey. Now, I want to quickly clear up a really common misconception by comparing VAWA to another protection you've probably heard of, the U visa. As you can see right here, they are very different. VAWA is specifically for abused relatives of citizens or permanent residents, and while it takes years, there is absolutely no annual cap on approvals. The U visa, on the other hand, is for victims of a broader range of qualifying crimes who help law enforcement. Because Congress capped U visas at just $10,000 a year, that backlog is currently stretching an unbelievable 7 to 9+ years. Okay, our final stop, Section 5, protections while you wait. So, how do you survive a half-decade wait? The very first layer of protection here is what's called a prima facie determination. Basically, it's a preliminary notice from USCIS stating that on its face, your petition meets the basic requirements. It's a hugely important early win because it unlocks access to certain public benefits, letting survivors get immediate support. However, under the recent policy shifts we talked about, these notices are frequently being delayed well past 12 months, or in some cases, skipped entirely.
Now, despite these crazy delays, the whole filing process is ultimately designed to yield independence. Filing that I-360 petition can eventually lead to a grant of deferred action, which temporarily protects you from removal and lets you apply for a work permit. And this is absolutely critical. A work permit gives a survivor the actual financial independence they need to permanently leave an abusive situation while they wait out the years for their green card.
But really, the absolute core of this safety net is confidentiality. Under federal law, specifically 8 U.S.C. 1367, USCIS is strictly bound to keep everything completely under wraps. They cannot contact the abuser, and they cannot share the fact that you even filed. Combined with that temporary protection from removal and the ability to work legally, these mechanisms are built to keep survivors safe while the slow wheels of bureaucracy keep turning.
But as you might expect, that safety net was recently put to the test. Back in 2025, an ICE policy came out that authorized the routine civil arrest and potential removal of non-citizens who actually had pending VAWA, U-Visa, or T-Visa cases. Talk about scary, right? However, a major federal lawsuit, ICWC v. Noam, resulted in a court ruling that slammed the brakes on this enforcement policy. This injunction essentially restored the prior victim-centered approach we're used to.
Just to be totally clear, this ICWC v. Noam ruling doesn't grant blanket immunity from detention. Your underlying eligibility for VAWA hasn't changed at all. What it does do is restore a crucial safeguard for the estimated 600,000 crime survivors currently stuck in the immigration backlog. It ensures that while they are waiting in that massive 49.5-month queue, they can still cooperate with law enforcement and live their lives without the immediate daily fear of a civil immigration arrest.
Which ultimately brings us right back to the core tension at the heart of VAWA today. On one hand, we've got USCIS implementing these strict, retroactive evidentiary rules and cohabitation standards, all in the name of program integrity. But on the other hand, we have the entire original humanitarian purpose of the law, protecting highly vulnerable survivors who are often fleeing abuse in the middle of the night without perfectly organized paperwork. So as processing times push past 4 years, how do we effectively balance strict verification with the urgent need to protect human life? It's a deeply complex reality and one that thousands are navigating every single day.